Many thanks to Legal Era and Akriti and her team for this opportunity to interact with colleagues from the legal profession. Uh, the topic today for me, my brief was to sort of look at tax really uh, as an instrumentality post what all of us have gone through in the COVID, and to sort of reimagine what the approach to tax could be going into the future. And what we've seen in the context of COVID and all of us have experienced is that there's been a transformational impact in the way that we work, and there has been a transformational impact in the way in which consumption occurs. And both of these are critical aspects for taxation, because in the realm of direct tax, we know that the broad principles are source or residence. And as people work in a more global environment, the situation is location for work in a manner is becoming less and less relevant. It's really the nature of the work and the quality of work that you do, which is predominant in terms of its impact. So if we sort of look at and reimagine tax on a going forwards basis, keeping in mind the sort of disruption that we had in terms of the COVID. And along with the COVID, we've had really a technological disruption as well. Zoom has sort of become central to almost 80% of business communications, and whether it's Zoom or it's a similar platform, all of us have therefore moved to a more electronic basis of addressing clients, addressing courts. Now, as we look at, some of the issues of the immediate future and maybe reimagine some of the issues, going into maybe a 5-year period, the three fundamental pillars for anything that we are concerned with in tax is A, the tax legislation, B, the tax administration, and lastly, litigation, which would come out of the interaction of what your legislation is and the manner in which it is administered. Now, if we look at all of these three aspects, and let me take each at a time, from a legislative perspective, we are seeing that from the previous approach, that all tax laws were really formulated by a country for a country, we are moving to a more multilateral basis of formation of tax legislation and tax policy. So, very early, we saw that first happen in the case of customs valuation. And that was the first effort where several nations got together under the banner of the WTO and came up with what then became the customs valuation law in almost 140 countries. And then we saw that sort of exercise recur in the context of transfer pricing, where the basic framework of the law is the same, as you look around several countries. And if we see the one area in which tax policymakers were most active, even during the phase of the COVID, was the entire effort being undertaken by OECD and by the UN now in terms of taxing transactions of e-commerce. And what we're seeing, therefore, is that all of these indicate a situation where in a more globalized world, where not only will people consume more globally, but will also work really in almost a borderless world, the aspect of tax legislation being formulated at a global level rather than at a local level is probably going to be one trend which is here to stay. And obviously the centerpiece of that at this point in time is the taxation of e-commerce. But it will not be surprising if that sort of approach carries over, to other aspects of taxation. And when you talk of a global corporation, and you ask the wish list of many global corporations, I think one of their wish lists would be for them to respond to a uniform tax legislation all over the world. Now, if that were to be so, then we are really seeing a replication of these efforts where you're seeing legislation formed not by one nation for itself, but legislations formed across multilateral bodies for a host of nations to actually adopt. And the path that we go in the context of taxation of e-commerce, because this is now no longer just a tax policy issue. We've seen, the heads of country at the G7, at the G20, all get involved in the process. So really, this is an issue engaging heads of state. This is not a minister of finance, minister of taxation or revenue type issue anymore. As this happens, of course, we need to balance the issue of sovereignty. And we've seen increasingly, especially in international arbitrations, India quite assertive of the fact that we see tax as a sovereign right for us to be exercised in the manner that we see fit, in terms of the will of our people and the elected government in our process. So from that perspective, I think we will see a trend of more multilateral formation of tax legislation. At the same time, you will see some nations seek to assert sovereignty. And among those who will most seek to assert sovereignty will actually be those nations which are in a way broadly referred to as tax havens. Because in a more and more transparent tax policy, in more and more unified tax legislation, really you're shrinking the place for tax havens to be able to operate. And their relevance over a period of time is really what is under intense scrutiny, whether it's from a national security perspective, because people are concerned about funding of drugs and terrorism, or the escapement of income or double non-taxation, which we are seeing that some of the largest companies in the world pay no tax anywhere in the world. So one part of this, as I said, is legislation. The second part of this, which is critical, is administration. And I think in how taxes are administered, sadly, India stands apart with a lot of countries in the world. And the general situation is that the Indian process of administration of tax is actually quite adversarial. And the root of that is that many tax collectors are really working to some sort of a set target which they have. So, they have a target from the Ministry of Finance, probably. They are trying to achieve that much of tax collection in their particular commissionerate or collectorate. And therefore, the entire approach is an approach to say, I have a target to meet. That target could have very little to do with income. That target may have very little to do with economic activity. And therefore, what you have is a target which may, in a manner, be significantly distorted compared to your basis of taxation, which is either income or the extent of economic activity in indirect taxes. So tax administration here in the Indian context probably needs a major overhaul. And that overhaul is really about an approach and about a behavioral standard. Because what we have today in much of the world is that the taxpayer sees his obligation to pay tax as some sort of a national duty and will pay it. A tax administrator in many jurisdictions is a facilitator to ensure the appropriate tax can most easily be paid by the taxpayer. In our situation, the process is much more adversarial. So you will see multinationals tell you that in many countries, it's a partnership between the business and the tax authorities, and everybody really works in some level of unison to ensure tax is appropriately and quite easily paid. In our situation, the process sadly has become very adversarial because the commissioner or the collector has a target. You as an assessee want to pay optimum tax. We must also acknowledge that there are some who ought to be assessees who don't pay tax at all or pay far lesser tax than they legitimately should. What has therefore happened is that tax administration in India is almost become like an activity which is a policing activity. You are suspected, people are suspicious, you are called in for summons. The previous lecture effectively sort of spoke of some of the ills and challenges of that sort of a system. So in tax administration, what we sort of need is really to move away from target-based tax administration and to make the process a facilitative process rather than a process of policing. And when you have an attitude which is more policing and which is more adversarial, obviously we get to the third limb of things, which is litigation. And as is well known, we have a few 100,000 cases in the system where our judiciary at various points is just dealing with an overload of litigation in general, but an overload of tax litigation as well. And tax litigation really means that assessees who are honest taxpayers, are spending more litigating, which is unfair. And in cases where government should recover monies, they are also pursuing litigation and really don't have money in hand, but are spending to try and get issues resolved in a litigation process. The issue that we have is, given the aspect that the tax administrator has a target, adjudication proceedings are not seen as fair. And therefore, adjudication proceedings will 99.999% of the time result in a negative order, which means the first appeal. Your adjudication is by a departmental officer. Your first appeal is before a departmental officer. Everybody is spending time to get to a tribunal, which is seen as being more impartial and more balanced. And that process is literally taking thousands of crores. It is taking thousands of man hours in an entirely unproductive engagement. And the one thing, if one had to reimagine this system of adjudication and first appeal, I'd really borrow from some cricketing concepts. The first thing that cricket did and benefited from is neutral umpires. I think when the man who issues you a show cause notice decides the show cause notice, or his colleague issues and he decides, the deck is completely loaded against you. And I think it is high time that we had a system where the responsibility of the tax department to issue a tax demand should end there. And we should have a neutral system, even at an adjudication stage, so you get fair judgments. And if you get fair judgments at that stage, the quality of justice goes up and the quantum of litigation goes down. The other situation is, even if you did go to a neutral or fair body, and let us say, given the number of ex-judges and senior administrators and bureaucrats we have, we could form panels, at least in all of the major tax jurisdiction. You refer the matter to them, they adjudicate. If the adjudication, either side, that is the tax department or the assessee, doesn't like, you have a cricketing equivalent of a DRS. You have a quick referral to a body of more experienced judges, of more experienced tax lawyers or bureaucrats, and you get an immediate answer. In that situation, quality of justice goes up, the number of appeals go down. That's one thing we need to do. The second thing we need to do is, you have literally lakhs of litigation for which we need a scheme of settlement, not something which comes for 3 months and 6 months, really something which says it's open-ended. You have a pending litigation in a window of 3 years, anyone can go and settle, and you have a system whereby you have an impartial body which looks at it, it rates the issue, and you are able to then offer settlements where you can say, okay, we will waive at 50%. If the case is not very clear, we will waive 75% if the assessee's case is strong. But we have to create an incentive for litigation to become cash for the department, and where assessees deserve to win, for them to be able to close these matters. So I think into the future, you're going to see some very, very drastic changes if we need to really become a destination for international investment, for international business, and even comfort our own businesses to be in a fair, open system which is not adversarial. To leave you now with really the last thought, which is, how could one imagine or reimagine the system of taxation the world over? And one of the thoughts that I've always had is that if we could at a global level do away with income tax and indirect taxes in this quite complex system, really we would have far more efficient economies. And the one way to look at that is, could we think of a universal transaction tax? And what do I mean by that? Every transaction which occurs in the world, given the technology we now have, is capable of being traced. Let us say for every transaction in the world, you had a tax rate, and I'm just throwing a number out there. Let us say $1 of tax, per transaction which is occurring in the world. And that $1 would get collected through the network of all the intelligence we now have in commerce. And that $1 would then, as per a pre-agreed system, get split between the consuming country and the country which is the supplying country. And therefore, you could split this in any ratio, let's say 50-50 or 60-40. And in this manner, literally every transaction would have an element of tax. The quantum of tax available could be of a proportion that we could not think of. So governments will be facilitated, particularly in developing countries. And you would have no income tax, no other form of indirect tax, because just collecting an X amount on every transaction of consumption would actually give us greater tax revenues globally than what we are imagining and collecting at this point in time. So I think, the next 5 to 10 years in tax will probably be as exciting as the next 5 to 10 years of the trajectory and pace of growth of business. And I do hope tax, stays step with business, because that is the need of the hour. And I think the COVID has really brought all of us front and center with the factor that technology is going to impact our lives far greater. If that's true of every aspect of our life, then it'll be true of tax as well. Thank you for this opportunity. And, it's always a pleasure to be on a Legal Era platform and talk to colleagues. Thank you very much.